have a horrible sinus. I think something popped up on my screen. A horrible sinus infection, and it's causing my voice to be spotty. But I'm filing. I was recently retained by the movements here. My understanding is that there was a default judgment entered in July of 2022, and they were unaware of that setting. The underlying case here is one of a form of a owner finance sale of the property in question to the plaintiffs. The case was initially filed by opposing counsel with a request for a restraining order when the plaintiffs were facing an eviction by the defendant. I think that all parties are not experienced real estate professionals, but in the course of the suit, it became apparent that prior opposing counsel, Mr. Edmond, was, sorry, not opposing counsel, he would be the counsel for my clients, Mr. Andy Edmondson, was having trouble practicing at the necessary level to perform his duties for the bar. And so he was ultimately stepped off the case, and then has presently been disbarred for failing to communicate with his clients, including settlement offers and whatnot. And I don't have any personal experience with him or this case before. I've relied on anything said by opposing counsel about how that went. But I think that evidenced by the necessity of a translator here, it became very difficult for the movements. They didn't even know there was a hearing for the trial. And so we're asking here for the court to reconsider a motion for new trial. We pled in our petition that in our motion that there's 3 reasons. One, of course, is to give the trial court a chance to correct what the appellant will claim on appeal as reversible error, preserve error for appeal, and extend appellate deadlines. We argue here that while there may be issues between the parties, that the final default judgment, which was rendered, is inappropriate given the lack of payment by the plaintiffs to the defendant.
I couldn't hear what you said. Lack of what by the defendant?
The default order awards $24,000 in attorney's fees to the plaintiff. It also outlines a agreement made between the parties, which is contrary to the contracts that were signed. So it's sort of like a statute of limitations argument, where I believe parole evidence would have been admissible, but when you don't have a hearing on it, it makes it hard to make an order then that makes a new agreement between the parties when there was one in writing. And so we'd like the opportunity to get it right. And that's the real problem, is that the default order is very thorough, but it wasn't reflective of an actual trial setting that would have had a substantive outcome. And so we have agreements between the parties in writing. And it's just fair because the person who was representing them clearly didn't give them the information, and they didn't know about the trial setting.
Did you have anything else?
That's it for now, Your Honor.
Response?
Your Honor, just to step back, the motion for new trial is unverified. As a result, my understanding of the law is you can't introduce evidence. So we're stuck with whatever's in that motion. Now, the authority that is listed by opposing counsel, it goes to not the issue of a new trial, it goes to whether you can take off and what the situation is when you have a lien claim, a lis pendens. That's what those cases are that are cited. So there's real problems there. There's also the problems that his client is a person who claimed her address on the eviction proceeding, and then when we filed the motion, absented herself for over a year. By her own admissions, by their own admissions, they were not available at that address for over a year. They also claimed that they hired him and paid him for a motion in February of 2022. Yet they didn't get around to asking about it for over 6 months later, which is unreasonable, which is part of the Craddock case. If you want a motion for a new trial, you have to show that whatever happened was not intentional or a conscious indifference on their part, but was due to a mistake or an accident. None of their actions during this case, whatever happened, I fully understand where they say, well, I never got hurt. Well, we tried everything. We tried sending people out over and over again to your address that you told the court that you were at. You didn't show up. You wouldn't take service. So how is that a mistake? And you also have to show up with a meritorious defense. You can't just show up and say, oh, this happened with Mr. Edmondson. Well, there's nothing that says that you weren't noticed. It just says that he was disbarred, but that doesn't talk to the fact that you were that you might have been noticed by Mr. Edmondson. How hard is it for Mr. Edmondson to have just forwarded emails? So there's nothing there that says a meritorious defense. And plus, you know, these people work very hard for their money. They've had to go through a lot of economic sacrifices to hold on to what they thought was a binding agreement with the defendants. And then my last point is, you know, Your Honor, this is one of 3 defendants. The other 2 are, I understand where the court has the ability to and the discretion to strike the whole judgment, but as to the other 2, they haven't shown up, and they have a final judgment against them, is my understanding. So that kind of concludes summarizes my arguments, Your Honor. And I apologize for some of the responses. They weren't proofread as well as they should have been.
So let's deal with kind of the first issue here, which is the lack of verification. I mean, the rules clearly provide that a affidavit needs to be attached, or at least the verification needs to be attached to the motion for new trial. So
yeah, that should do it. I'm looking to see if I did not even. I thought that we had the information to do it. So.
I'm not sure I can hear you. If you could speak up a little bit.
Yeah, I no offense to anybody. I thought that we had a verification in order to do a verified answer. And so I'm just making sure it wasn't filed with one and I'm losing my mind, because I have all the evidence there. I think that the verification just didn't find its way onto that motion. May I ask for leave of the court to file to amend this to have making sure it's verified? I feel that we had a verification in the office that didn't make it to the motion. I won't ask the court to rule on something that's not verified.
Marquez, do you agree to that?
No, Your Honor. We've gone through hell the last 100 days, 95 days. We're on the 94th day today from your date.
But the order was July. This was filed 2 months ago. I
And
think
that's when you
months is
should have put the
stretch.
verification on.
Oh, they were in the office. It was a mistake, but that's
I'm not
6
asking
months.
you to testify. You're pleading, and pleadings aren't evidence.
But it's not 6 months. You're acting like it's
It
been
is
that
6
long.
months. 6 months was
July.
was
It
over
on
September
7/2.
25th.
No, it wasn't. No, and we
So
filed
you
it 2
didn't have
months
enough
ago.
days.
You're
Is
acting
that
like
what
they
you're saying?
didn't move on this,
Okay.
you know?
Your Honor,
And they never got, they
he
paid
should
thousands of dollars.
limit
attorney to
his
file that
arguments to the court, Your Honor.
Guys, you're kind of talking over each other.
I can't,
So let's
yeah.
let's do
I'll
this.
refile it, but the point
Yeah,
is.
just go
it's
ahead
not-
and if you want to file a motion for leave, you can. If it's
Thank
agreed
you.
to, that's okay too.
I understand. But
but,
it just,
at
it
this-
hasn't been that long. They spent thousands of dollars with that attorney, took the money and ran. You know, I look, guys, I think it's valuable to get it right, Your Honor.
But we're the
I'm-
victims.
it's my shame on me.
Hey,
for
hey,
not
hey,
getting it
one
on
at a
the record
time.
there.
Yes, sir.
Shame
We're
on
the
me for
victims,
not.
Your Honor. We did everything on our part.
Okay. At this point, the motion is denied without prejudice to filing a motion for leave, and then we can determine it at that point. So,
Yes, Your Honor.
all right, you guys, let me see. Did you present an order, Mr. Marquez, denying?
No,
the
Your Honor, but I
motion?
have it in today.
Yeah, make sure that it says at the beginning that this was heard on October 24th, 2022, not that this was on this date, but put on October 24th, 2022. It's just a garden variety denial without prejudice, and share it with Mr. Opposing counsel, and then make sure that you get it to the court by tomorrow morning at 9.
Thank you, Your Honor.
Thank you, guys. Have a great rest of your
Thank
day.
you, sir. Likewise.
Bye-bye.
Okay, our next hearing is Hambrook versus Luminant Mining Company. Is everyone here on that case? It's not quite 9:30, so it's 9:29. Is everyone here for that?
Carlos Lucas here for the plaintiff. We're here, counsel for defendant Luminant is on, but I don't see counsel for defendant Warfab.
Is that Mr. Brett?
Yes, I have Luminant, Your Honor. Good morning.
Good morning. All right, do you expect the other attorney to show up? It is not quite 9:30, so.
Your Honor, I think she filed a joinder of defendant Luminant's motion, so I expected her to show up. I did try to
Okay.
reach out to her just before this hearing in an attempt to resolve the issues. I didn't get through, but I did leave a message. Counsel for Luminant and I have spoken this morning and have reached a tentative agreement. I was reaching out to Ms. Spring, counsel for Warfab, if she was on the same page. I suspect she would be, given that she joined on Luminant's motion, which is asking for continuance of the trial setting in this case to resolve some of the issues. I'm in agreement with them with respect to the continuance. It was just a matter of, how far do we need to push this back to get everyone the time that they need.
I want to hear from everybody on that. Why don't you call her and just have her join?
Sure, let me try to reach her again. Yes, let me forward that on to you. We're on the hearing now. I'm sorry. Sure. Yeah, let me forward that on to you then, okay? Thank you. Your Honor, she was asking for the link, so I'm forwarding the link to the Zoom
Okay.
hearing. I just sent it to her, so hopefully it should be on shortly.
looks like there's 3 sets of defense counsel. Is that still the case, or that's just what the clerk's office shows?
Your Honor, the other defendant is Joyce Crane. We have reached a tentative settlement with them, Your
Okay.
Honor. I didn't expect them to show up.
Ms. Spring, are you there?
Yes, I'm here. My apologies. Thank you, Carlos, for the link.
So I guess we're hearing a motion to compel, and then there was a discussion about, this is a very old case, about possibly continuing the case as well, which I want to talk to you all about. So let's first off, let's go on the record on DC 207704, Hambrick versus Luminant Mining Company. Counsel, make your appearances.
Carlos Lopez, and I have the pleasure of representing Mr. Eric Hambrick.
Ben Britt here for Luminant Mining.
Katie Spring here for WFHV Inc.
All right, first off, I understand we have a motion to compel that there's been an agreement reached on. Is that correct?
Well, Your Honor, the motion, and I don't want to speak for the defendants on this, but the motion surrounds a couple of different issues of which time is needed in order to resolve the issues that are brought up in the motion. And there's a couple of different motions essentially in one of which is opportunity to depose experts, need more time to evaluate my client's medical conditions and lost wage claim. I understand Katie Spring and her client have joined on the motion, and she also has a motion for leave related to seeking a motion for summary judgment hearing. This matter is set for trial already for November 1st, next Tuesday. The only way to resolve all those issues before then is for a continuance. So that's what I've agreed to do, is to push this hearing, this trial setting back. I wasn't for necessarily the continuance, but in order to resolve all the issues and get everyone the time that they need to be able to do what they want to do, I've agreed to a continuance. The only issue was, a timing of everything. I think
All right,
initially.
you need to be a little bit more specific on what you're talking about.
Sure. So defense counsel is wanting time to take deposition of one of my experts that was designated in August. Between the time that they've asked for the deposition to now, my expert, or to trial, my expert isn't available, and we were beyond the discovery time period as well. That's one of the issues. So they want time to take his deposition, but he's not available before trial now. The other issue is, from what I'm understanding, is because my client has continuously received medical treatment, recent supplementation of discovery responses has brought to light his condition, for which defense counsel wants an additional opportunity to review those medical records, seek additional evaluation from their own experts, and supplement the reports with respect to those as well, including the lost wage claims that accompanies that.
If I may, Carlos, Your Honor, on September 29th, the wage capacity claim jumped from between 50 and 150 to over 1.6 million. And that was on the basically last day of discovery. So that was a bit of a surprise, to say the least. And then now they're saying, well, he needs a hip replacement surgery. That was also disclosed on the last day of discovery. And that it's been recommended that he no longer return to his prior employment. That also was disclosed on the last day of discovery. So we're getting some things here at the last minute that were a bit of a surprise, Your Honor.
Okay. Well, you guys are set for trial, I think, next week, right?
Yes, Your Honor.
Okay.
Carlos and I had discussed the last week of March, potentially of next year, be like with the 28th, I think would be the Tuesday of that week that the court usually sets the trial dates.
Let's see. We have 23 cases set for trial that week.
We would be one of the oldest, I suspect.
Let me see. What is your cause number? DC 20 what?
7704, Your Honor.
Yeah, right now you'd be number 3, it looks like. No, why do you guys need that much time?
Well, Your Honor, me and defense counsel, Mr. Britt discussed, I think originally his motion, he sought a 45-day continuance. That puts us in the middle of December. I currently have a trial set in the beginning of December. That's a case set out in California that we're specially set on. And then we discussed just timing issues. You know, people are usually unavailable beginning of January. And then I didn't want to push up against spring break. We both have children. So that's why we kind of settled on
How
March.
long is this case going to take to try?
Sitting here, Your Honor, I mean, we're already going through the motions of preparing for trial. I don't see this case being longer than a week, Your Honor.
Yeah, I mean, I could see 5 days, but that'd be.
I agree.
Okay.
We've already exchanged, you know, I guess what would be our preliminary depot designations. It doesn't look like most of these deposition designations that we would be using at trial are all that lengthy. So that's why I think that a week probably would be sufficient because we can get to those pretty quickly.
It's just a bit expert heavy.
Yeah.
I mean, because right now, next week, you guys are behind a special setting, which is kind of why I wanted to talk to you guys anyway. But, you know, who knows if that case is going to go. And so that was, you know, one of the issues I wanted to talk to you about. And you said what date again you wanted to reset it to?
March 28th is what we were looking at. And if the court would prefer a February, I think we could live with that as well, Your Honor. We were looking at March 28th.
And that's why I had reached out to Katie Spring this morning, and I didn't run the day by her yet.
I apologize. I'm fine with whatever works for your schedules. I'm open February and March, so.
Okay. I'm just trying to find a date. You guys would be number one. It's not ideal, but March 7th, you'd be number one. I know you said you had spring break, maybe. Do you have spring break the next week?
Yeah, that week of the 13th is pretty common.
Yeah.
And I'm actually set in Bowie, Texas for a trial that's case even older than this one, believe it or not.
On that same week or?
March 7th.
Okay. Let me see. So March 21st, you guys would be number one. That might be the best date.
Yeah, I'm open that date, Your Honor.
That'll be fine, Your Honor.
Rhonda, are you there? Can you hear me?
Yes, Judge, I'm here.
Go ahead and reset this case to March 21st.
Which one is this, Judge?
The one that's set for next week, the Hambrook case.
Hamburg, got it. Okay, for March 21st.
21st, yes.
Okay. Got it.
You said that this allows you to work out everything on your compel, correct?
I believe so, Your Honor. I mean, I think that creates the time necessary. I've spoken with Mr. Britt about this, I'll give him some additional supplementation for his experts to consider. It gives him time to supplement with his experts. Him and I discussed pushing all the deadlines by the same equal amount of days that the trial setting being set. I think, I don't know if Ms. Spring wants to speak on that.
No, I
But
think
I
that
mean,
sounds reasonable.
if we all are pushing everything, I think that gives us enough time to kind of iron out all these issues, Your Honor.
Okay, sounds good. We'll go ahead and reset it, and good luck, and you guys have a great rest of your week, okay?
Thank you.
Your Honor, you as well.
But, Your Honor, would we be submitting a new order to you for the sign on the trial setting with the new deadlines?
We'll send you, well, if you want new deadlines, you'll need to do a new order, but we're gonna
Okay.
send you a new trial setting.
Okay, well, I'll circulate a new schedule and order with the push deadlines in, Your Honor. I appreciate it.